Good afternoon, everyone, and thank you for joining us. My name is Ken Director, and I am joined by my colleagues in our Bradenton office, Mary Hawk and Bryony Swift. And we are going to be discussing upgrading your documents or updating your documents. Why update your documents? There are typically three principal reasons. One, which is not a justification unto itself, but if you're going to update your documents, removing obsolete references to the developer is always a good idea. Number two, bringing your documents up to date with the statute. And we're going to be discussing in detail how you can do that and whether or not it's a good idea. I tend to think it is. And then finally, we're going to talk about a lot of policy issues, which is where all the discussion takes place. We're going to talk about a mandatory or voting thresholds for the owners, and if they pose an insurmountable burden to you to get things done, maybe that's the starting point for any update to your documents. We're going to talk about the allocation of maintenance responsibility and making sure that there is clarity in your documents, because I've told a lot of clients that when you have a plumbing problem, I would prefer for you to call a plumber rather than a lawyer. Number three, we're going to talk about alterations, whether by the association and whether the board should have discretion up to a certain financial threshold. And we're going to talk about alterations to the units by the owners and what should trigger a requirement for association approval and how that approval is obtained. We're going to talk about the use restrictions, which is where a lot of the fun occurs. We'll talk about especially the older documents, the prohibitions against commercial use, which really don't fit anymore in a society where everybody has a cell phone, a tablet, a desktop. We're going to talk about guests because most old developer documents do not address guests, but they are an issue, especially in the portions of Florida that are popular with Airbnb. We're going to talk about pets, which is a great discussion, and it has become even more interesting with the advent 35 years ago of the amendments to the Fair Housing Act. We're going to talk about prohibitions on vehicles. A lot of your old documents prohibit trucks. But if you drive to the grocery store from where you're at, probably 30 or 40% of the vehicles you will see constitute trucks. So there were no such things as soccer moms or SUVs or other more desirable vehicles that constitute trucks 40, 50, 60 years ago. And then finally, we're going to talk about screening. And screening is your ability to approve or disapprove sales and leases in your community, and whether or not you can adopt provisions that actually have some legitimate teeth. So for starters, when you approach amending and updating your documents, do you do line by line amendments? Do you amend and restate your documents in their entirety? And that's a discussion to have with your counsel based upon how old your documents are, how much modification is required to fully bring them up to date, and whether or not your members are going to support a complete rewrite of the documents, because amended documents have strike-throughs for all the language that is coming out and underlines for all the language that is coming in. So for the few people who are going to read every word of the proposed amendments, that is what they might want to see. Amended and restated documents, in my opinion, tend to produce a better end product, but you don't necessarily have the ability to see every single word every word that's coming in. The other difference between the two is if you do line by line amendments, your members can vote line by line. They can approve some, but not all of the amendments. An amended and restated document generally has to be approved up or down on the whole document. So, Mary, I want to toss the first comment to you, because a lot of people out there are saying, we just have too much apathy and too high of a voting threshold to be able to get this done. So what do we do?
Right. Well, member apathy is very common. It's a widespread epidemic. People want things to be done in their community, but they don't want to participate in getting them done. So if you've ever thought about amending your documents, the first hurdle you've probably encountered is, how are we going to get these passed? We have a provision in our declaration that says, 2/3 of the entire voting membership must pass these amendments, when you can't get, a handful of people to participate regularly in your meetings. So you might want to first look at just your amendment provisions, and each governing document is going to probably have its own amendment provision. The declaration may say it, requires this number of people, of members, to pass the any amendments, and the bylaws amending provision might be different. But you'll want to look at those, and a lot of times we look at that first, and we say, what threshold can we bring it down to that would be manageable, so that you can get business done, in your community. And amending your amendment provision first as a sole amendment would be, the answer. However, that amendment to amend your amendment provision has to be passed by that initial threshold that's already in your documents. So it might require a little bit of a PR campaign, some knocking on doors to get people to vote for the amendment to the amendment provision. But then once you have that done, amending your documents is going to be easier once you can have that lower threshold.
What type of lower threshold are most communities asking to go to?
Well, it just depends on what you think in your community will pass. I know, Brian, you might have written these more than I have, but you might look at your quorum provision, and then are you asking people who vote, who are at a meeting, to have an amendment pass pursuant to a threshold of people attending the meeting, or is it amendments will pass according to how many, a certain percentage of the entire membership? What has been your practice, Bryony, or your?
I like to amend to have a majority of those participating at the meeting. That way, if it's a contentious issue and everybody shows up to vote, you're still getting the majority position. If it's something not a lot of people are interested in and you can barely get a quorum, you're still able to do business and move forward if your standard is a majority of a quorum or a majority of those voting interests participating.
Well, and it's worth reiterating that any vote that is based upon a percentage of everybody means those who don't vote count as a no vote. What a lot of my communities have preferred is a standard where they still require a super majority of those voting, like 2/3 or 75% of those voting, but no less than a majority of the entire community, or some base level, so that you have at least enough support for the amendments that you have a substantial percentage of the community. But this is a good place, folks. This is a good place to start the process if you have historically faced difficulty getting enough people to participate. Mary, a little bit about what are the governing documents? What are we talking about here? And what are the general differences between them?
Right. Well, you have several governing documents, and there is a hierarchy to them. The articles of incorporation come first. They're not as helpful to you on a daily basis. They basically incorporate your association as what you are likely a not-for-profit corporation, and it's filed with the Secretary of State. It creates the corporation, but sometimes there can be some sneaky provisions in your articles of incorporation, so you'll want to be familiar with them. The next document is your declaration. That's the major one. It's recorded in the public records of the county where the property is located. And that's where you're going to have your use restrictions, how members can and can't use their property. As Ken was saying, the alteration and maintenance responsibilities, the rental restrictions, those types of things are in your declaration. I know some of the questions we got from participants before today were about how to find your very, very old governing documents. And so, as I said, you would go to the official records of the county that the property's at. And let's say in Manatee County, it's the Manatee County Clerk of Court on the website. And you want to search the official records, not court records, but the official records. And if you have a book and page number, that's great. You'll find it immediately, or you may have to type in the name. Some of them are so old they're not online. You'd have to physically take yourself down to the clerk's office and see if you can find a copy there that way. And I know a lot of you are frustrated if you have very old documents. They're hard to read. they're very old. They might be on microfiche. They're hard to read. Restating your documents will create an entirely new, beautiful, easy to read, up-to-date, computer-generated document. So, that would be what you would ultimately want. But you can't. I've had clients retype the declaration because it's so hard to read. But I would suggest there be a heading on every page saying this is just a retyped copy. It's not the official one. But anyway, your declarations, your covenants, your promises, your use restrictions that run with the land. Next are your bylaws. That's how your corporation is run. It might also be found in the public records. Some are not required to be recorded. Some are an exhibit to the declaration. So go all the way down to the bottom, and you might find them there at the end of the declaration. But it talks about the members and their voting rights, the board of directors, how meetings are run, the powers and whatnot. Well, one of the questions was how to get rid of longtime board members. Well, you might want to address some things in your bylaws, changes about terms of office or things like that. And there are some statutory requirements that the statute says if your bylaws don't include this, they must. So you'll want to make sure those are in there. The next document is your rules and regulations. We got a lot of questions on rules and what are the differences between rules and your other documents. Well, in terms of what we're talking about today, you're going to need member votes to change your declaration and likely your bylaws. The rules are board passed. The rules are passed only by the board. You have to give certain
all the time, but most of the time.
Most of the time, you have to give certain notice of the meetings and whatnot. But they're usually the tool that the board uses to pass rules. But the number one thing to remember about rules is they implement what's in your declaration. They do not contradict your declaration. They don't contradict any right that's reasonably inferable from your declaration. You can't have a declaration that says, all owners can have one pet and then pass a board rule that says we're no pets. You can't contradict, and the rules can't be arbitrary either. So we do a lot of work with boards on reining back what you can do as far as passing rules when they really are trying to change the declaration and not doing it correctly through an amendment.
That point bears reemphasizing, Mary, that do not try to do through your rules what you should do through an amendment to your declaration, your articles, or your bylaws. You also have to remember the rules are subject to a test of reasonableness. So it's up to whoever the judge or the arbitrator happens to be as to whether or not they find the rule to be reasonable. And also the rules can change every time the board changes. If the board can make and amend rules, that means the next board could reverse everything this board does. So there are a lot of communities in the decades I've been doing this, and I'm sure Bryony and Mary, you've seen it too, where you get a set of documents from a client and all they've done is adopt rules and never try to amend their documents. And they've got a lot of rules that are arguably unenforceable. I'll give you a very good example. We're going to talk about it later, folks. A lot of communities address guests through their rules. But a lot of older documents say the unit is intended as a single family residence to be used by the owners, their family members, their tenants, and their guests. So regulating guest occupancy through the rules could easily be viewed as running afoul of that language in your declaration. It is really important if you want to address guest occupancy, again, especially in the Airbnb era, by doing so through amendment to your deck. Mary, did you want to add anything?
The first thing I look for when talking about rules is whether in the declaration or the bylaws the board actually has the power to pass rules and regulations. It's nice to have that in the governing bylaws or the declaration also. And I was going to mention a sort of a kind of rule is our board policies because we did have a question on that. And those are sort of resolutions the board makes and maybe puts into writing. Common ones are a policy on how and how often members can make official records requests, policies on how the board meetings will be run. I have a lot of, unfortunately, communities passing civility policies for how their meetings will be conducted.
Me too.
Yeah, but a question we got was, and I guess this applies to rules and policies, is how detailed should rules or policies be? And when I get, a collection policy a board wants to adopt and it's 7 pages long, I say, this is too detailed. It will trip you up. The homeowners will use it against you. The minute you forget to do line item 3J on your collection policy, they're going to say that the collection is invalid. So I look at rules with my clients so that they're not so detailed that they create a ready-made defense for a homeowner to use it against you.
And by the same token, there are some restrictions or rules that should be detailed. For example, if the board has the right to approve new Windows installations, you should be detailed as to what windows are going to be permitted so that you can have a uniform standard. But there are other operational provisions like the one Mary just alluded to, where too much detail can create gotcha circumstances. I want to move off of this. A final comment, though, with regard to updating your documents. There are certain provisions that are almost always going to require 100% approval. You can't change the unit boundaries in a condo without the consent of the owner. You can't change the percentages by which people share common expenses and common elements. And you cannot alter the appurtenances to the units without the consent of the owners. So you need to be mindful that there are certain amendments, including their voting rights, which simply are going to be sacrosanct and are going to be very difficult, if not impossible, to amend. Bryony, I want to talk to you about bringing the documents up to date with the statute and keeping them current with the statute.
Well, first, I'd like to address which statute applies to your documents and touch on Kaufman. Kaufman language is that those magical words as amended from time to time. And Kaufman was a case about what law applied to a declaration provision. If your deck incorporates the law as amended from time to time, did that mean the law on the day of the incident or the law on the day that your deck was created? So the Florida Constitution prohibits a substantive law from retroactively impairing a pre-existing contract, and a Florida declaration is a contract that runs with the land. So under the Florida Constitution, the law that applies is the law that existed when your declaration was created. But since Kaufman was decided about 50 years ago, there's been a body of case law and a common practice that the definition of the law within your declaration is defined as Florida statutes as amended from time to time. And that brings every statutory change that happens after your declaration or your amended and restated declaration is recorded, every statutory change is automatically incorporated into your documents. So there are two schools of thought on this, and Ken and I are of different schools of thought. So I'm going to try and be fair to both. For me personally, I like to define the law as the Florida statutes as they exist on the date that this document is recorded, unless otherwise specified within this declaration. And then I go through the declaration and I specify in each section where I want to bring in future statutory changes, where I expect those to be beneficial to my client. I will include that Kaufman language, those magic words, Florida statutes as amended from time to time. And I do it in the majority of provisions. I bring the Florida statutes into the estoppel provisions, into the collections provisions, the insurance provisions. I want those future statutory amendments, but I also want a little control. I want to protect my client if the legislature gets a wild inspiration and passes something that my association clients wouldn't benefit from. Like this summer, the legislature passed an HOA storage bill requiring HOAs to allow storage in backyards under certain conditions. And no HOA wants to implement that. And so if the Kaufman language isn't in the definition of the law that applies, then that kind of future statutory change would not apply. So I do use Kaufman throughout, but I don't use it in the definition of the law, and I don't use it in every single section. Now, the other school of thought there is to use Kaufman language in the definition of the law that applies. And that is beneficial to boards. It makes things a little easier. Every future statutory change applies to your documents, every single one across the board. So there's never any doubt or question as to what law applies. As I said, I like a little more control than that, but ultimately it's up to the board to decide whether they want the Kaufman language to cover the entire declaration and every future statutory change, or whether they want to be more specific. And another point for specificity there is that if the legislature makes a change in the statute that's beneficial in a section where I haven't incorporated the Florida statutes as amended from time to time, it's not expensive or complicated to do a little amendment and bring that statutory change into the documents. But
I just want to interject. Remember, the first comment that we talked about with Mary was that you could amend your amendatory clauses to make that process more feasible and more likely to be successful. So I just want to underscore Bryony's point that if you do that, then you have an easier time if you want to go back and do spot amendments to incorporate changes to a statute that occur in years to come. Bryony, I also think it's important for you to make clear that certain changes to the statute are going to supersede your documents no matter what, right?
Absolutely. So Kaufman language applies to bring substantive changes to future statutes into your declaration, but the Constitution already allows for procedural changes to impact what's in your declaration. For an example, I'll give you Florida Statute 718-112 subsection 2. That statute applies no matter when your declaration was put in place, and it says your bylaws are deemed to include certain provisions, and it spells out these provisions that the legislature has overwritten your bylaws with. And those provisions apply to your association. One of the amendments that we frequently see is an amended and restated set of bylaws to bring all of the changes in 718-112 into your bylaws so that there's no confusion. Because if you have a very old set of bylaws, I have clients with bylaws that are older than I am. If you have those, then there are going to be contradictions that predate the legislature's detail in 718-112. I will also note that there's 718-112B1, and there are sections in that statute that allow you to modify the mandatory provisions in your bylaws. So as an example, unless a lower number is provided in your bylaws, your quorum is a majority of the voting interests. So the legislature has given condominiums the power to create a lower quorum, but it says if your documents don't give you a quorum, then here's the one that we're going to give you. So with an amended and restated set of bylaws, we update anything that's conflicting. We remove the language that's old to bring your bylaws in line with the law that the legislature has been allowed to overwrite your declaration with, and those are the procedural statutes.
Mary, when you do amended and restated bylaws, do you incorporate the statute as amended from time to time wholesale in the bylaws, or do you do spot amendments in the bylaws too?
I defer to Bryony and tell her to get with the board and see what would make more sense with this particular association.
Bryony, given your sort of spot incorporations, how do you feel about the bylaws being a document that just incorporates the statute as amended from time to time, but not necessarily do the same with the declaration?
I agree. The sensible route is to have the bylaws, the law that applies to the bylaws be the Florida statutes as amended from time to time, because the legislature is going to overwrite what your bylaws provide anyway.
And I assume
you might as well have something in the document to give your members clarity when they're referring to the bylaws so that they know how to respond or how to act.
So I assume for the declaration, good examples of where you would incorporate future amendments are, for example, the collection of delinquent assessments, the amount of the late charge, the amount of the transfer fee that you can charge for sales and leases, as you said, the insurance coverage provisions, And those are important to understand, and that's certainly a valid approach, particularly if you reduce the vote required to amend the documents. I want to shift you, Bryony, to the notion of remedies, which is also a place where you may want to incorporate future amendments to the statute. But I would like you to talk a little bit about remedies, particularly when you have to consider invoking a self-help remedy.
Yes, well, self-help remedy is all the buzz among the community association lawyers right now. See what you're missing out on, folks. Self-help remedies are remedies where the association can affect a resolution. They can go onto the property and cure the violation. 2 of our district courts of appeals have recently ruled that self-help remedies are an obstacle to an association receiving an injunction. So generally there are 2 ways of going about bringing a resolution to a violation. I mean, your owner can voluntarily comply with the documents, but if you're going to have some pushback, you can either move for an injunction, get a court order requiring the person to comply, or you can have a self-help remedy. And that may be, the self-help remedy to mow the lawn, where you go onto the property and you mow the lawn because the homeowner hasn't mowed the lawn, and you charge them for that service. The issue here with Florida's 6th and 2nd District Courts of Appeal is they've both ruled that a self-help remedy is something that the association must attempt before it can move for an injunction. And that's a recent change. The law wasn't like that before. The association had the obligation or had the option to choose which way they wanted to handle it. And more often than not, they would move for an injunction to get a court order to require the homeowner to take action. I don't have many association clients that want to pay to put a new roof on someone's house because their roof is filthy and falling apart. They want the homeowner to put a new roof on the house. So I would recommend that you limit self-help remedies in your documents, that you take out. If you would never ever put a new roof on somebody's home, then take that self-help remedy out of your documents so that you don't have to attempt to put a new roof on somebody's home before you can get a court order requiring someone to bring the state of their roof in line with the standards in your documents.
Bryony, would you take a different approach? Would you take a different approach and say a condominium where an owner has allowed his unit to turn into a science project? I mean, replacing a roof obviously would be a concern if we're talking about a homeowners association with separate freestanding homes. But would you take a slightly different tact with a multifamily building like a condo or a co-op?
Oh, absolutely. I've had associations where a homeowner has turned their unit into a science project, and there's mold growing absolutely everywhere, mold growing up the sleeves of the clothes hanging in the closet. I can still see it. It was so impressive. Anyway, yes, I would advise the homeowners or the condo association to go into the unit and remedy that situation, because that mold is spreading through the ducts, through the walls, it's in the common elements. And so for the safety of the building and for the safety of the other unit owners, you want to take immediate action as quickly as possible to remedy that situation.
This is a good point to interject more general comment, which is what I hope you're taking away from this discussion is a conversation about updating your documents requires an extensive discussion between the board and its council, because there is a lot to consider. And you need to know what it is you are doing when you update certain provisions of your documents, particularly something like self-help that may impact you when you get into an enforcement posture, but also particularly with self-help when you get into a situation where you need to get in and remedy a problem, whether it's mold or whether it's an infestation with an owner. The ones who let their units get the most disgusting are also the ones who never let your pest control service in. So it is an important part of the discussion. Mary,
Can I interject one thing about self-help, especially when you have to go in and remedy a hoarding situation, which I've had before, or the mold or the pests, and you do incur, the association incurs can incur quite a charge for having to go in and remediate mold and whatnot. We make sure that the remedy provision turns that charge into an assessment, because then you could possibly lien for it and foreclose on it. Otherwise, it's just a damages judgment you might get against the person, and you may never see that money.
No, and when that owner sells, the damage judgment doesn't go with the unit to the new owner or become a liability of the new owner. It basically leaves with the owner who's selling his or her unit. So that's a very important point. Thank you, Mary, that if you're going to have self-help and you're going to advance expense, you need to have the right to lien for it so that you can actually have a chance of collecting it. Bryony, I want to come back to you. You mentioned earlier when you talked about, incorporating the future amendments to the statute, you talked about insurance. Speak a little bit about insurance, and let's focus this one on the condos, because HOAs are a different animal altogether, and co-ops have virtually no guidance in their documents. Although I'd like you to talk about what you would recommend for an insurance provision if you were updating a set of co-op documents.
Well, I think both condominiums and cooperatives should adopt the insurance provisions that are in the condominium statute. 718, 111, sub 11 is a very detailed, thorough provision assigning insurance obligations and standards for every portion of the building and the personal property within the building, so that everything is accounted for and everything is insured. I think that co-ops have so little guidance, and there's very little to go on usually in co-op documents. So I would suggest they adopt the same thing. They adopt the standards from 718, 111, 11.
For HOAs, obviously, if you have separate freestanding homes, everybody insures their own home. But there can be real issues, Bryony, if you have an attached line of 4, 6, 8 townhomes, all with party walls, and everybody carries their own property damage insurance for their part of the building. That just sounds like a recipe for compounding a disaster.
Absolutely, it is. You need to know who's responsible for every component within that wall that separates those two units. And we've also seen issues with roofs, who's responsible and who decides when the roof is going to be replaced if the HOA isn't responsible for that change, but the individual owners are responsible to pay for it. So yes, there's a lot of complexity there, and your documents need to spell out exactly. Sorry?
They might share a roof, and how do you split it up, and how do you make one replace the roof when the other wants to replace the roof?
And they share a common wall too, an exterior wall that is contiguous. Could you imagine having one owner rebuild and his neighbor who shares a contiguous wall, and as Mary points out, a contiguous roof, didn't get insurance and doesn't want to pay to restore his unit? It's a bad idea. That kind of thing, that kind of responsibility, in my opinion, should be centralized to the association. So that,
and then one wants shingle roof and one wants tile, and that's where your comment comes in about putting specifications in your rules, that this is the kind of shingle you shall use and the color and all of that.
So Mary, at this point, all the board members are thinking, God, do I even want to do this?
They're running for the hill.
Where do I turn in my pink slip? Maybe this is a good time for you to talk about the concept of indemnity.
Right. So your declaration is going to, and if we rewrite it, will have an indemnification provision. And what that really means is that your association, as the corporation, is going to defend you from personal liability. So if people go crazy and want to sue you personally as a board member, excuse me, the association is going to defend you. You're going to also want to have the D&O, the directors and officers insurance, that will help with that coverage. One thing to think about, though, when you're putting all of this onto the association is, will this added liability on the association affect any of the current contracts you have? So you want to make sure that you're not violating any contracts you have by indemnifying all your board members. But I would never sit on a not-for-profit board that didn't have indemnification and didn't have directors and officers insurance. And that means you're encouraging people to volunteer to be on your board. Now, it's not going to cover that board member who takes a hammer and hits the fellow board member over the head during a board meeting with it, you know, you have to act reasonably and within your duties as a board member to be covered. But you'll want that, and you'll want that coverage and that protection from liability, and you'll want to also make sure that your committee members are similarly covered. If you have a landscape committee or an ARC committee, you'll want to make sure those committee members are similarly protected from personal liability.
Mary, this would probably be a good point to offer just a quick synopsis of what Chapter 718 identifies as 3 circumstances where board members can face personal liability.
Well, I don't have that committed to memory.
You already covered the first one, which is if you commit a criminal act.
Gross.
The second one is if you vote to hire a roofer because he has agreed under the table
the
house up the road for free.
Mm-hmm.
And the third is where you exercise such a reckless disregard for the safety of the person and property of your owners that you have put them all at risk. A good example of the last one is if you have a pattern of criminal activity going on your property and the board declines to spend the money to implement a proportionate response in terms of security, board members may face personal liability. So the circumstances where there is personal liability are intentionally limited, but they're not non-existent. So, sorry, I didn't mean to sandbag you with that one.
That's all right. I just wrote a little presentation for a homeowners association specifically on 720, and you also have to jump into statute 617 that governs your not-for-profit corporations, and there's some pretty good conflict of interest standards in there too. The big takeaway from that is no kickbacks, and
yeah,
that happens.
Yes, it does, unfortunately.
It really is unfortunate.
We were going to talk about taking out developer references, but I think we've already alluded to that. And since we're streaming through our available time, I want to move to the next item, which comes back to you, Bryony, which is regulating rentals and particularly Airbnb. And if you are successful in getting your documents amended, are there limitations on the group of owners to whom the amendments actually apply?
There are limitations to whom the amendments would apply, and I'll touch on those momentarily. But as for Airbnb, I like to put an Airbnb advertising prohibition in my leasing restrictions. It's so much easier to prove that the neighbor has an Airbnb listing for a short-term rental than it is to prove that the people who stayed in his unit for a week are not his family, not his cousins. You don't have information when those folks leave after a few days stay. You have a real difficulty proving that they were Airbnb tenants, but unless they write a glowing review, in which case you can use that.
No takebacks on that one. It's a very important point that the prohibition is on the listing itself. That's a very, very important point. Thank you, Bryony.
And it does work. It does cut down on those Airbnb units. And it's also not inhibited by one of the 2 statutes that limit your ability to regulate rentals. So in condominiums, there's 718.110 subsection 13. It's been the law for about 20 years, 19 years now. And that limits the condominiums association's ability to limit 3 particular facets of renting. So an amendment can't outright prohibit rentals, or folks could be grandfathered from a provision absolutely outright prohibiting rentals.
I just want to be clear for our audience, pardon me, Bryony. What Bryony is talking about is that these are amendments to the statute that say that even if the amendment passes, you get the vote you need to pass it, the amendment will not apply to people who didn't vote for it if they fall into one of these categories.
And then you have to keep the voting information, the proxies, forever, so that you can prove 15 years from now how they voted on this rental amendment. It's a difficult process for the association. It's really arduous. So 718 110 sub 13 says an amendment prohibiting unit owners from renting their units or altering the duration of the rental term or specifying or limiting the number of times the owners are entitled to rent only applies to the unit owners who vote yes affirmatively for the amendment and those owners who take title after the amendment is recorded in the public records. And I want to be clear here with 718.110 sub 13, there's only three things. You can't, or you have to grandfather folks who vote no if you are outright prohibiting rentals, if you are altering the duration of the rental term, and if you are specifying or limiting the number of times a unit owner can rent their unit. It does not prohibit you or require you to grandfather someone from your Airbnb advertising prohibition or other restrictions. Yes.
Let's talk about that for a second. There are going to be people who are going to say, well, why bother? All three of us have seen a lot of communities where there's been a wave of absentee owners who want to rent their units. If you're going to amend your documents to effectively curtail leasing, you can't wait until 40% of your owners are absentee owners who want to lease their units. Because even if the amendment only requires a majority, it means 40% of your owners can still do whatever they want. They're still under the former documents. So this is one where you need to be sensitive to the constituency of your owners, because you can get to a point of no return with regard to rentals. So I've said to a lot of clients who have said, why bother if it's not going to apply to everybody? And my response to that is someday it will.
Stop the bleeding now. Yeah.
Yep, precisely. That was very important. Thank you, Bryony. Mary, I want you to take on the even more challenging topic of screening sales, a right of first refusal, establishing a for-cause basis for disapproval without providing a substitute buyer, the mortgagee exceptions.
Right.
A lot of people come to us and say, can we have some teeth in our screening provisions? And the answer is, can they?
Well, for renters, yes. For purchasers, the one thing we learned probably like the first day of property law in law school is that the ownership of property comes with a bundle of rights. And when you get into condominium and homeowner association law, there are legal ways that people give up some of these rights to their ownership of their property when living in an association. But one right that's really difficult to infringe upon is someone's right to sell their property. So a lot of associations want the right to screen and approve or disapprove buyers. This doesn't apply to renters. Again, it's easier to screen and disapprove renters. But if you're saying someone's going to sell their unit and they bring a purchaser to you and you're going to deny that purchaser, you're going to have a hard time doing it. What's going to happen is the association has to either purchase that unit if you deny that purchaser, or find a replacement purchaser of that unit. And there are ways that you can sort of imagine the ways that this could be misused. So there are parameters of how you determine if it's a reasonable sale, if it's a bona fide offer, if it's a market price. But the long and short of it is, if you're going to deny a purchaser, the association's going to have to purchase the unit itself or provide a substitute purchaser. There's a few minor exceptions to that that came out of a case a while back, such as, for instance, if you are a bona fide 55 and older community, you comply with the Housing for Older Persons Act, you do your surveys, you're a bona fide 55 and over community, then yes, you could deny a purchaser who applies and does not meet your 55 plus rules. The other one I thought of perhaps is if you have a declaration that prohibits corporate ownership. What if a corporation applies to be a purchaser? That hasn't been tested in the courts, but I would think, and I would hear what Ken has to say, that might pass muster too. You have a rule, you have a declaration amendment that says no corporate ownership. You could deny someone based solely on the fact that they're a corporate owner. You certainly can't deny someone because of their race or religion, and we get into all the fair housing things like that. There are a few exceptions to the purchaser rules. Is that if a mortgagee takes title to a unit at foreclosure, you have to let them. The same you should apply that if an association takes title to a unit at lien foreclosure, you shouldn't have any impediments in your documents to that. But denying purchasers is difficult.
It's risky business. A couple things. First of all, I've started to discourage clients from prohibiting entities, corporations, LLCs, trusts from owning units, because I think owners should have the right to engage in meaningful estate planning. But the provision that addresses the manner in which units are titled, and this should be a declaration provision, should also have corresponding restrictions on occupancy so that a corporation doesn't send down the employee of the month and doesn't create a revolving door in terms of occupancy. And I think you can do that while allowing owners to have the flexibility to do reasonable estate and financial planning when they title their units. The other thing I wanted to chat about briefly, Mary, is I have drafted provisions, and I will state up front, this has never been the subject of an appellate opinion in the court in the state of Florida, other than the one where a purchaser is facially unqualified to occupy. Like you said, in a 55 and older building, a couple with young kids under 18 are simply not qualified to live there. But I also believe that you can adopt narrowly drafted, very objective criteria which would constitute good cause to turn down a buyer. I've debated this at Florida bar seminars, and has it been tested in the courts? No. For example, someone who's been convicted of a violent felony or a felony that involves violence to children. I think most of you listening would like to have the right to say, no, we want to turn that person down and don't want to have to go find a substitute purchaser. I think someone who has lived there as a tenant or a guest and committed numerous infractions, and you have the demand letters to document it, and then your worst nightmare comes true, which is this person says, I like it here so much, I want to buy. You might want to disapprove that purchaser. Where I want to discourage the people listening is trying to do your own credit underwriting analysis is something you should not do. Of those of you listening, I doubt many of your communities have a qualified person with banking or underwriting experience to evaluate the creditworthiness of a buyer. The association should not be looking at tax returns and financial statements, because those can change tomorrow. Your financial fortunes can change in a day. What you are looking to protect when you look at someone's financial background is you're not looking to protect your future ability or their future ability to pay. What you're looking to protect is your future ability to collect. And that is why one of the criteria that I suggest when I rewrite documents is that the purchaser cannot be getting financing beyond, say, 80% loan to value, so that they have to put some skin in the game, so that there's an equity cushion above the first mortgage to secure your lien. I find that to be a reasonable restriction, especially given what we all suffered about 15 years ago when people were getting 100% or 105% loan to value financing. I want to reiterate, don't rush out and start amending your documents to say, we can turn you down without providing a substitute purchaser for the following 50 reasons. If you picked up a 3-foot putt on the green on 18 to win the Nassau, that's not a good reason. But if a member of the Manson family gets out on parole, or if a convicted pedophile gets out on parole, you might want to have the right to say no. Someone who is borrowing 100 or more % loan to value, that's a potential collections problem. So those are the issues I would like you to address there. Mary, I'm going to come back to you, and I'm going to talk about a sensitive topic, and we're beginning to run short on time, so we need to be a little bit more expedient. I guess that includes me. Alterations fall into two categories: alterations by the association and alterations by the owners. What do you typically recommend for alterations by the association?
Well, you have to first understand the difference between an alteration and just typical maintenance and repair. You're pretty much always going to have the ability to maintain and repair and replace your common elements. Alterations would fall more into the category of material alterations, which have a definition that's gleaned from some case law. And typically, the association cannot make material alterations to the common elements without a unit owner vote. If you don't have a threshold in your documents, then you need a 75% unit owner vote to make these material alterations. And of course, with the voter apathy we've been talking about, that's going to be hard to do. A lot of documents will put in a dollar amount or a percentage of the budget that says actually, the board can make these certain material alterations if the alteration doesn't cost more than X. I normally don't like putting an actual dollar amount in, but instead put a percentage of the budget.
I agree. I agree
so
with
that you can make some alterations without having to get that enormous vote of the unit owners. And I've also seen and recommend that the association be allowed to make safety related alterations without getting a unit owner vote. Like
which are debatable as to whether or not they're even alterations. I did want to add one comment on that last point, Mary. I agree with you that a percentage of the budget is the better yardstick, because as inflation occurs, a dollar amount becomes obsolete. But I like to include two percentages of the budget, one for a per alteration basis and one for cumulative alterations within a fiscal year.
Right. I had an association was responsible for the driveways and wanted to make each driveway an alteration that they were allowed to do on their own without getting unit owner vote. But it was a project of 222 driveways. And do you take the entire project cost or each driveway cost? So, those are things to think about, how you're going to explain that. Unit owner alterations. The biggest one I see in HOAs, do you have an ARC? Do you have an architectural review committee to sort of manage alterations people are making to the exterior of their homes? Do you have that ability in your documents to approve exterior alterations? One of the common condo alteration thing, and I just wrote one of these, was a high rise on the beach. They're very seasonal here over on the West Coast. I'm sure you all do too. We have lots of snowbirds, and so there's a definite season, and they wanted to put a restriction on unit renovations during season. And we're not talking about emergency repairs or pipe bursts or anything, but they want to put in a new kitchen or do some renovation. And we looked at, can we restrict them from doing those alterations during the season that we defined as, I think it's October 15th to May 1st or something like that. And if you have the right language in your documents, which this one did, giving the board the ability to ensure the peaceful enjoyment of the property by the other residents, we found that we could put that restriction in place because of the disruption, because of the usurpation of the elevators, and based on that power that the board had. That was a good seasonal restriction that we decided to do. You want me to talk about some more specific?
Well, I'd like you to talk about, for example, let's take a condo. What do you think would be the appropriate criteria to trigger a requirement that the owner get approval from the association? I mean, throwing down a rug is one thing, replacing your refrigerator is another thing, but what types of alterations should require board approval?
Well, in a high rise, you're going to have any alteration or replacement of your flooring. It's going to have to meet with some criteria and be approved because of the soundproofing. Anytime you're thinking of taking out a load-bearing wall or a column, something like that. I mean, like you said, there are things you can do within your unit that nobody cares about. We don't need to govern, but things that affect the common elements, affect the interior of the walls, affect the soundproofing for your neighbors, those kinds of things would need to be a governing.
I tend to cast a fairly broad net. I generally say that any work that requires a permit requires board approval, if for no other reason, so that we can verify that you're using a licensed contractor who has in fact pulled a permit. I also tend to include guidelines for contractor insurance, which is another area where specificity in your protocols would be useful. These are important topics. Mary, I want to move you to another important topic because we're down to our final 5 minutes. We've talked briefly about pets. I don't want to get into the Fair Housing Act. That could be another whole hour. I talked about commercial use and parking and corporate ownership. Talk to me about how many of your clients are looking to adopt restrictions on smoking.
Most condos want to. Of course, an HOA, you wouldn't be able to restrict someone from smoking in their homes, but you can restrict it on common elements, condominiums. Most are adopting restrictions for smoking on common elements. We have restrictions on smoking on balconies, in hallways, in stairwells, and there is case law that you can restrict people from smoking in their unit. I like to say it needs to be backed up with some facts of we have shared ducts, we have shared airways. I don't know about you, I haven't done too many where they restrict smoking in the actual unit, but I know it can be done.
And it's difficult to do smoking unless you just do it as an all or none thing.
And then what is smoking? Does it include medical marijuana? Does it include cigars? That's something
I tend to write that it's any smoked material. One of the interesting questions, and this is for another webinar on fair housing issues, because you can use medical marijuana legally in Florida, and you can also smoke marijuana in your home without violating the law, but marijuana is available in non-smokable form. So can you require someone who needs medical marijuana to ingest it with a gummy or a brownie or whatever they choose to bake it into? That's an interesting question. I want to close though, and Bryony, I want to come back to you. We started with addressing your amendatory provisions. There are some procedural things that communities can do to position themselves to have more success with a document update, such as the different voting mechanisms that are now available, such as the use of the proxy 90-day window. Can you elaborate on that for folks? And can you also talk about the benefit of having a town hall with council present to answer everybody's questions?
I believe a town hall is very beneficial, and I always hold one when I amend a set of documents. It allows those homeowners who are naturally suspicious to ask me about all the provisions they're suspicious of, and I can explain the language and we can talk it through to where their suspicions are alleviated. It gets the community to buy in when they understand, when they're not intimidated by the legalese. So I think a town hall is profoundly beneficial.
I agree.
I would also suggest implementing online voting. Making it easier to vote will get you more participation when you set these documents for a vote of the community. You can also pass a board resolution to allow for online participation, to get your quorum through those owners who are attending via Zoom. It's an online participation resolution that you want to adopt. And if you haven't received the participation that you need by the time.
Pardon me, I'm going to pose it as a hypothetical for you, Bryony, because I like to put this in terms that everyone can relate to. You're an 80-unit community. You need 75% of everybody to approve the amendments. You have your meeting. You have 50 people attend in person or by proxy or by online or by other means. And of the 50 who are attending, 45 vote for everything. So you've got 90% of those participating voting in favor, but you're 15 votes short of the 60 votes to get you to 75%. What do you do in that circumstance?
Well, if you have a quorum, and you do with that kind of turnout, you have someone motion to suspend the meeting to a time, place, and date certain within 90 days.
And that's a membership vote to do this, to recess the meeting.
Yes, yes. So you want to have someone in the audience prepared with that language so that they can move to suspend the meeting. Now, if you don't have a quorum, you can have someone motion to continue the meeting, and the same, you need a time, date, and a place certain within the motion. And it has to be within 90 days. That's not 3 months. 3 months and 90 days are two different calculations. 90 days is a couple days shorter than 3 months. And you don't have to schedule the meeting for 90 days from the date of the meeting that you're continuing. You can continue the meeting for 30 days and meet again and try. You're so close. And then you
recess as many times as you need to within the 90-day window, right?
Absolutely, but those proxies are good for 90 days. So you want to make sure you're not meeting on day 92.
I want to mention something about the proxies, Bryony, which is proxies are, quote, limited proxies, which means you're authorizing your proxy holder to vote specifically for the amendments. But when I do proxies, I automatically grant the proxy holder general powers unless the absentee owner specifically checks off to say, I don't want to grant general powers. And I do that specifically so that the secretary or whoever is holding all the proxies can vote on this particular motion to recess the meeting. So it is important to look before the meeting at how many proxies the secretary or the default proxy holder is holding and how many of them granted general powers, because that many votes can be cast in favor of the motion to recess. So that's a very important point. We've tried to cover a lot in an hour. We could talk for another couple hours about updating your documents. First of all, Mary and Bryony, thank you very much. I'd invite either of you to provide any final thoughts you have.
Stay educated to all of you board members and managers. And I know we didn't get to all your questions, but we do have other classes in board trainings, especially I really would love to talk about EV charging stations, e-bike rules, because I just wrote an e-bike rule about the fire hazards of electric bike batteries and lots of things you ask questions on. Get with us and see if we have a class that you could possibly request about it. But continue to be educated because the law is changing, and you have this responsibility as a board member and as a manager to know what you're doing and doing it correctly.
Couldn't agree more. Bryony, final thought?
Well, since we're out of time, I'll just thank you for the opportunity to present, Ken. Thank you.
You're most welcome. And my final comment, and this is going to sound very self-serving, don't try to do this yourselves.
Or we'll send Bryony over to give you the class on the unlicensed practice of law.
Well, the other problem is if you write them yourself, it's highly likely they're not going to say what you meant for them to say.
Exactly.
And with that, I will thank you all again for attending. Another sincere thanks to Mary and Bryony for the excellent coverage of this topic. And we thank you all for attending and wish you a pleasant afternoon.
Thanks. Thank you.